Good morning. I'm glad I got everyone's attention. Please join us and stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I hereby call the meeting, the 14th meeting of the Pennsylvania Public Utility Commission for the year 2015 to order. Before we go on to our first order of business, we do have an introduction. I'm going to ask our Director of Office of Special Assistance to make the introduction, Cheryl Walker-Davis.
Thank you, Madam Chairman. We'd just like to note that May Chow, a Gettysburg College intern, is present with us today, observing our processes for future consideration of a future in public service. May, could you please stand?
Welcome, May. Our first order of business is the approval of our minutes. We call on Commissioner Cawley.
Thank you and good morning, Chairman. I've reviewed the minutes of our meeting of July 8th, 2015 and move that they be adopted as submitted.
Second.
We have a motion to accept the minutes of July 8th, 2015 by Commissioner Cawley, a second by Vice Chairman Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. We'll call up our Director of Office of Special Assistance, Cheryl Walker-Davis, to lead us through our agenda for today.
Thank you, Madam Chairman. Good morning, Commissioners.
Good morning.
Good morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items. Commencing this morning with matters on behalf of the Bureau of Administration, it is recommended that the commission adopt the recommendation to approve a side letter to the current agreement with the Commonwealth Bar Association.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second.
We have a motion by Commissioner Cawley, second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing to page 2 of the public meeting agenda, it is recommended that the commission adopt on behalf of the Office of Competitive Market Oversight the proposed final order with regard to implementing a joint natural gas distribution company natural gas supplier bill similar to that that's directed for the electric industry, noting the statement of Commissioner Whitmer.
So I have a motion to accept the staff recommendation.
So moved.
Do I have a second?
Second.
Motion by Commissioner Cawley, second by Commissioner Powelson. Discussion, Commissioner Whitmer.
Thank you, Madam Chair. And I would like my statement entered into the record as if I had read it in its entirety. Today, the Commission is considering the recommendations of the Commission's Office of Competitive Market Oversight to enhance the natural gas supplier information included on the Natural Gas Distribution Company bill. I want to first take a minute to thank my colleague, Commissioner Jim Cawley, who has been an unwavering proponent of strong competitive markets, for his partnership in launching the Commission's investigation of Pennsylvania's retail natural gas supply market. In December of 2014 is when we launched that investigation. This investigation is similar to the one that was led by Commissioner Powelson, who is an equally strong advocate for competitive markets, along with Commissioner Cawley for the retail electric market. We seek to facilitate competition and implement changes that will best allow residential and small customers the opportunity to realize the benefits of choice in the retail gas market. The enhancements that are approved today will not only help consumers develop a recognition of and relationship with their NGS, but will also create increased consumer awareness of the competitive retail natural gas market as a whole. I am encouraged by this progress. These measures, along with the evaluation of the current status and future needs of pipeline infrastructure measures, along with the evaluation of the by the Pipeline Infrastructure Task Force, are an integral part of the Commonwealth's realization of the full potential of the opportunities that are provided by Marcellus Shale. Ensuring that we have market designs that allow consumers to make informed choices will become even more important as more Pennsylvanians Pennsylvania's electric generation shifts toward natural gas in light of the EPA's Clean Power Plan under Section 111D of the Clean Air Act. In fact, for a one-month period in April, the nation's electric generation fueled by natural gas exceeded that of coal for the first time since the U.S. Energy Information Administration's monthly generation data was starting to be collected in 1973. In Pennsylvania, our generation mix remains diversified, but natural gas is closing the gap. And these dynamics, combined with our proximity to Marcellus Shale and our responsibility to ensure that Pennsylvanians can fully avail themselves of the opportunities it provides, make consumer education even more critical. I wholeheartedly support today's action, and I look forward to continued efforts to enhance and encourage active participation in Pennsylvania's retail natural gas market. Thank you.
Thank you, Commissioner Whitmer. Any further discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with the presentation of agenda items and matters on behalf of the Office of Special Assistance, it is recommended that the Commission adopt, appearing on page 3, the recommendation in the complaint proceeding involving Danielle Douglas versus Philadelphia Gas Works.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Powelson. Any discussion aside from my statement? Well, I'd like to state for the record that, excuse me, that's the next one. No further discussion. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And now, with regard to Janet Armour versus Verizon Pennsylvania LLC, we recommend the adoption of the staff recommendation there appearing, noting the statement of Chairman Brown.
Where I obviously have a statement since I announced it before I was going to make the statement. Do we have a motion to accept the staff recommendation? Do we have a second?
Second.
We have a motion by Vice Chairman Coleman, second by Commissioner Whitmer. Any discussion aside from the statement that I'm about to make? Thank you. Just like to state for the record that the dispute arising in this matter is rooted in consumer concerns about Verizon's network changing from a copper network to a fiber network. The FCC just promulgated rules on how companies advise the states and consumers as they move to replace copper with fiber in the technology transition order at docket number 13-5. The FCC adopted some commission positions and set out detailed state and consumer notice requirements that should go a long way to reducing disputes like this in the future once they become effective. If there's no further discussion, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with the presentation of items on behalf of the Office of Special Assistance, it is recommended in omnibus fashion that the Commission adopt the items appearing on pages 4. On page 5, it should be noted that the top item with regard to PUC Investigation and Enforcement Bureau versus Samuel C. Duncan has been postponed until public meeting of September the 3rd. The omnibus continues to include the remaining item on page 5 in the proceeding involving In Loving Arms Family Resource Center, Inc., as well as the recommendation appearing at the top of page 6 in the matter involving the PUC's Bureau of Investigation and Enforcement versus Raymond P. Sutherland.
So I have a motion to accept the staff recommendations.
So moved.
Do I have a second?
Second.
Motion by Commissioner Whitmer, second by Vice Chairman Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With regard to the next recommendation involving the proceeding pertaining to Verizon Pennsylvania LLC's and Verizon North LLC's implementation of the reclassification of certain wire centers as competitive, there is the motion of Commissioner Whitmer, as well as statements from you, Madam Chairman, and the other commissioners, noting that the statements of Vice Chairman Coleman and Commissioner Powelson is a joint statement.
Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
Motion by Commissioner Powelson, second by Vice Chairman Coleman to call up the staff recommendation. On discussion, I know we have a motion by Commissioner Whitmer.
Thank you, Madam Chair. This is a very lengthy motion. I will attempt to summarize it. However, there are some important things I think that need to be said. So with that, I would like my motion entered into the record as if I had read it in its entirety. Before the Commission today for consideration and disposition is the recommended final implementation order in the Verizon proceeding in the above referenced dockets. The recommended final implementation order addresses the comments filed in response to the Commission's tentative implementation opinion and order, which was issued in this proceeding on June 1st of 2015. The tentative implementation order requested comments on certain proposed clarifications and directives to facilitate the implementation of the March 4th, 2015 reclassification order that determined basic local exchange service competitive in certain geographic areas and waiving certain Commission regulations. Comments were received by Verizon, the Office of Consumer Advocate, and Full Service Network. The issues being addressed through this motion are the application of the product guide and Section 64201 reporting. So addressing the first issue, the application of the product guide. In both the Commission's reclassification order and the tentative implementation order, we addressed the legal authorities that will apply in Verizon's competitive wire centers with regard to informal and formal complaints that are filed with the Commission. Our tentative implementation order specified that the product guide governs in competitive wire centers only when it does not conflict with the Public Utility Code and/or Commission regulations that were retained in competitive wire centers. To the extent our tentative implementation order can be interpreted to place the product guide as legal authority on par with a tariff, I wish to clarify that the product guide does not have the force and effect of law, as does a tariff under applicable law, including prior decisions of the Commission. Let me be clear. The product guide does not trump the code or the Commission's retained regulations in competitive wire centers. Nevertheless, there is a need to clarify that the Commission may consult the product guide for guidance as to whether Verizon's conduct in a particular case is reasonable under Section 1501 of the Public Utility Code. Although the Commission may consult the product guide to help determine compliance with Section 1501, the Commission will still assess the reasonableness of Verizon's conduct in a case based on the totality of circumstances in accordance with Section 1501. Section 1501 of the Code is the overarching legal authority applicable in all customer complaint cases, and the tentative implementation order simply sought to clarify that with no applicable regulation or product guide provision, the Commission's analysis is limited to what is reasonable under the facts and circumstances in a case in accordance with Section 1501 of the Code. Further, the Commission should retain the requirement that a copy of the product guide applicable to basic local exchange service, including all future changes, must be filed with Commission staff on or before its effective date. I firmly believe that the Commission should receive an updated product guide to carry out its responsibilities. Accordingly, I recommend that Verizon shall be required to provide an electronic copy of all future product guide changes to the Commission's Bureau of Technical Utility Services and the Bureau of Consumer Services on or before effective dates of such revisions. Moreover, requiring Verizon to maintain current copies of its product guide with the Commission is consistent with the additional powers that were conferred upon the Commission in Chapter 30. This includes the Commission's Chapter 30 responsibilities regarding quality of service and the ordering, installation, suspension or termination, and restoration of such service. In addition, it helps the Commission to adequately address consumer inquiries and/or complaints. However, I believe that it is also necessary to rescind our proposal that Verizon file future changes to the product guide with the Commission staff 10 days in advance. Also, it is not necessary at this time for Verizon to provide the product guide to third parties as requested by OCA and FSN. On balance, I find that the 10-day advance notice requirements would not advance our goals of granting Verizon competitive flexibility and, in fact, may be anti-competitive. Consumer education issues are important regarding specific Verizon wire centers where standalone basic local exchange services will be provided either on a competitive or non-competitive basis. The Commission has proactively taken a number of actions in issuing appropriate guidance in this regard. On this basis, I encourage Verizon, in an informal or formal complaint case filed by a customer, to clearly, accurately identify the individual wire center that is the subject of the complaint and whether the complaint at issue concerns a competitive or non-competitive wire center. Such timely and specific identification of facts will better contribute not only to the resolution of such complaints, but will also substantially lessen the administrative burden on the Commission and the company. Moving to the second issue, Section 64201 reporting, which is further separated into two subcategories, the first being the annual statewide reporting, and the second, reporting by individual wire centers or by aggregate competitive wire center and non-competitive wire center. In the Commission's tentative order, we propose certain modifications to the Section 64201 requirements. In response to the tentative implementation order, OCA filed comments on the following two issues. Number one, whether the Commission can direct statewide reports without a breakdown by competitive and non-competitive wire centers in accordance with Section 64201 of our regulations for all rate centers in the Verizon service territory. And two, whether the Commission's reporting requirements should be broken down by individual wire center or be submitted in the aggregate for competitive wire centers and non-competitive wire centers. So taking up the first subcategory of annual statewide reports, OCA comments noted that the Commission did not waive reporting regulations in non-competitive wire centers and objects to the Commission's waiver of regulations beyond those granted in the reclassification order. Based upon my review of OCA's comments, it is necessary to modify at this time the tentative implementation order to limit the Commission's waiver of the reporting requirements to the 153 wire centers to which this Commission granted competitive classification. The Commission's reclassification order stated that our conclusion was based on the limited scope of the waiver as applying only to Verizon and competitive local exchange carriers operating in the 153 wire centers that are found to be competitive. The scope of this proceeding does not permit the Commission to extend the waiver of the reporting requirements to any other wire centers than those included in the Commission's March 4th reclassification order. In addition, the Commission's tentative implementation order also proposed that certain information be reported in accordance with the Commission's waiver. In the tentative implementation order, the Commission recognized that certain reporting requirements are no longer necessary to accomplish the goals of the Commission's regulatory obligations as set forth in the reclassification order. In this case, the reporting of information beyond basic service under the retained regulations of Section 64201B will not gather the necessary information to evaluate the affordability of basic service as prescribed in ordering paragraph 15 of the reclassification order. In order to extend the partial waiver of the reporting obligations beyond the 153 wire centers designated as competitive, Verizon will have to file an additional petition for waiver of the reporting requirements pursuant to Section 64201 so that those portions of the regulations can be waived on a statewide basis. Turning to the second subcategory and the last one, reporting by individual wire center or by aggregate competitive and non-competitive wire center. In the Commission's tentative implementation order, we proposed that each Verizon company will file an annual statewide report not broken down by competitive versus non-competitive wire centers. Upon review of the comments in the response to the tentative implementation order and the Commission's May 2015 secretarial letter, I retained the aggregate competitive versus non-competitive analysis for the collection and reporting of residential accountant data as proposed in the secretarial letter. The reclassification order sought to assess whether market forces are sufficient discipline to the provision of jurisdictional telecommunications service in competitive markets as a whole. And while I do firmly believe that the competitive market forces will be sufficient, if in the future market discipline is applied unevenly in various wire centers, we may wish to analyze how the market functions as a regulatory surrogate on a more granular level and may seek more granular reporting. However, at this time, we believe data collected and reported on a competitive versus non-competitive basis and not at the individual wire center level is sufficient. Thank you for bearing with me through this lengthy motion, and therefore I move that the Office of Special Assistance prepare an order that is consistent with this motion. Thank you.
I second the motion.
We have a motion by Commissioner Whitmer to amend the staff recommendation with a second by Commissioner Colley. Any discussion on the motion?
I wish to, because I seconded it, I wish to support the motion. And as I will state in a moment, I fully support the motion except for the very last part regarding reporting requirements. That will come up as a separate item in our later Verizon matter on the agenda this morning.
Any further discussion on the motion?
Are you asking for statements at this point?
Statements at this point.
Very good. I'd ask that a statement from Commissioner Powelson and myself be entered into the record as though we read it in its entirety. There's a lot to be discussed this morning on the tentative implementation order around the product guide and reporting requirements. And I'm sure our audience can understand that these have gotten to be fairly technical issues. So I will spare the reading of our statement into the record this morning and just ask that it's entered in as we had read it in its entirety. Thank you.
Okay, if there's no further statements or discussion.
Chairman,
Yes.
I wish to enter my concurring and dissenting statement.
On the motion or on?
Not on the
final
motion,
vote?
but okay. Or if you're going to take them separately, I'll wait. Thank you.
Okay. Any further discussion on the motion to amend the staff recommendation? If none, all those in favor say aye.
Aye.
Any opposed? On the motion?
Aye.
On the motion, all those in favor?
Aye.
We have two ayes?
Yes, I said aye.
Okay. I say aye as well, so do we have any nays?
Are two of you dissenting?
We have two people not voting.
No, I'm an aye.
Oh, I didn't hear you say aye, I just didn't hear.
We're ayes.
Okay. 5-0 on the motion to amend the staff recommendation. On the final vote on the recommendation as amended by Commissioner Whitmer's motion, any discussion?
Yes, Chairman.
Yes. Commissioner Colley?
I wish to have my concurring and dissenting statement entered into the record as if I had read all of it. My dissent here is consistent with my dissent to the original Verizon competitive classification order and our May 19th, 2015 tentative implementation opinion and order. As noted, I concur in Commissioner Whitmer's motion today, except for the last part regarding the reporting requirements. Her motion would adopt aggregate competitive and non-competitive wire center data collection. I think you must do it by individual wire centers, and again, that will come up again in a separate order this morning. I dissent this morning because I continue to believe that Verizon did not begin to carry its burden of proof in this case, and this commission to this day does not know what the true level of competition is in this Commonwealth in the telecommunications arena, let alone in the 153 wire centers that were granted competitive status in this order. I commend Commissioner Whitmer for her effort to make clear that the Verizon product guides do not have legal status, and that we still have an ability under Section 1501 of the Public Utility Code to determine whether service is reasonable in a particular instance. As I said, however, in my dissent originally, I fear that Verizon will find it convenient sooner or later to allege that our general powers under Section 1501 violate Verizon's due process of law because there are no underlying standards to implement the very vague and general authority given to us by Section 1501. That is so because the original order, as implemented today, eliminated a number of our regulations which provided the standards to determine whether service is reasonable or not. But with that fear, I don't wish to diminish my colleague's effort to make this, what I regard as a very flawed order, work. So therefore, I partially concur, but for the most part, I dissent from what's being done today and wish to be recorded in the negative.
Thank you. I'd like to make a statement on the final vote as well. First, I want to thank the Office of Special Assistants for the quality and depth of their work on this issue. Today's decision allows Verizon to file changes to their product guide on or before the day the changes go into effect for all changes except price. The product guide is an important document to educate consumers, the Commission, and the public about changes in the service provided in Verizon's reclassified exchanges. It would have been better to adopt a 10-day advance filing period originally proposed, or perhaps a 5-day period. Advanced filing facilities facilitates informal disposition of issues sure to arise. That is not the same thing as mandatory approval by the Commission. Today's decision also limits who can get information. The concern with harm arising from disclosure to third parties, particularly the OCA, even though they are a statutory advocate and competitors in the market, is better addressed by confidentiality agreements. Verizon and competitors already use those at the Federal Communications Commission level. They warrant consideration here. Today's decision confines the categories reported in the 64.201 annual report to competitive and non-competitive. They are not broken down by wire center, a better approach given the reclassifications orders substantial impact wire center consumers not reporting categories. But today's decision reverses an earlier decision to extend our waivers to wire centers that were not even in the record. The Commission wisely avoids legal error by limiting the decision to the record. Other considerations also warrant support despite my concerns. The filing period for product guide changes can always be modified, particularly if the consumer education impact changes. The parties can work out voluntary confidentiality agreements. The category approach can be adjusted if things change, and more importantly, the annual report decision is confined only to record wire centers. So for that reason, I will be voting in the positive. If there's no further discussion, we'll take a vote on the staff recommendation as amended by Commissioner Whitmer. All those in favor say aye.
Aye.
Any opposed?
No.
The motion passes 4-1, noting the dissent of Commissioner Colley.
Continuing with the presentation of agenda items on behalf of the Office of Special Assistants, turning now to page 7. In omnibus fashion, it is recommended that the Commission adopt the recommendations appearing on page 7, commencing with the recommendation in the proceeding involving Daniel Chornenke versus West Penn Power Company, continuing on to page 8, through and including the last item on page 8 pertaining to the joint petition for approval of an interconnection agreement of Commonwealth Telephone LLC and CenturyLink.
Do I have a motion to accept the staff recommendation?
So move.
Do I have a second?
Second.
Motion by Commissioner Colley, second by Commissioner Whitmer. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On behalf of the Bureau of Technical Utility Services, again presenting in omnibus fashion, we recommend the adoption of the items appearing on page 9, except the item pertaining to PECO's petition seeking approval of a distribution system improvement charge, noting that that matter has been postponed until public meeting of September the 3rd. The omnibus continues with the remaining item on page 9, as well as the first two items appearing on page 10 through and including the application proceeding of Source Power and Gas LLC.
Do I have a motion to accept staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Colley. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With regard to Wellsboro Electric Company's tariff filing for approval to update its rules and procedures on customer choice, we've got the motion of Commissioner Colley.
Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
We have a motion to call up the staff recommendation by Commissioner Colley, second by Commissioner Whitmer. Under discussion, we have a motion of Commissioner Colley.
Thank you, Chairman. I ask that it be placed in the record as if I had read it in its entirety. It's a rather technical motion. It is, or it concerns a request for approval of a tariff by Wellsboro Electric Company. It proposes to implement various changes necessary to update Wellsboro's rules and procedures on customer choice in order to achieve compliance with current commission regulations and PJM procedures, as well as to it proposes to change electric generation supplier charges for various services. The motion proposes to adopt, with modifications, some of the proposed changes and to reject others. The motion attempts to recognize the fact that Wellsboro is making a good faith effort to support standardized transactions to remove existing barriers to electric retail competition in its service territory. And it also attempts to recognize this is a very small territory. It does not have a lot of electric competition. But with that said, I ask that it be adopted in its entirety without me reading all of it, and that the Office of Special Assistance prepare an order consistent with the motion.
Do we have a second on the Colley motion?
Second.
Motion by Commissioner Colley, second by Commissioner Powelson. Any discussion? All those in favor of the motion say aye.
Aye.
Any opposed? Motion passes 5-0. Now on the staff recommendation as amended by Commissioner Colley's motion. Any discussion? All those in favor say aye.
Aye.
Any opposed? The staff recommendation as amended by the motion is adopted 5-0. We're waiting on you.
Thank you, Madam Chairman. If we can go back to the vote on the Verizon North case and clarify for the record the fact that the joint statement of Vice Chairman Coleman and Commissioner Powelson contained a partial dissent to the vote on the amended motion.
We understand that their statements had partial dissents, but when we ask for the vote, they give the vote how they want to be recorded, and we acknowledge that there's partial dissents in their statements.
Correct.
If they would like to go back and reconsider the vote, I will accept a motion to do that. Seeing none, the vote stands as is, and people can go to their statements and note the parts that they will dissent in.
Thank you, Madam Chairman.
you.
Continuing with the presentation of agenda items on behalf of the Bureau of Technical Utility Services in omnibus fashion, it is recommended that the Commission adopt the recommendation in the application proceeding involving Brightergy LLC at the bottom of page 10, as well as the recommendations of staff appearing on pages 11 and 12 through and including the recommendation in the proceeding involving Bell South Long Distance, Inc., DBA AT&T Long Distance Service, and their application for the discontinuance and abandonment of inter-exchange carrier reseller services.
Do we have a motion to accept staff recommendation?
So moved.
Do we have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Law Bureau, commencing on page 13, it is recommended that the Commission adopt all of the items appearing on page 13, the recommendations in the proceedings involving First Energy Pennsylvania companies filing to implement their plan to address various items identified in the Commission's order of March 30th, as well as the remaining 2 items through and including the recommendation in the proceeding titled as Act 129 Energy Efficiency Program Phase 3.
Do we have a motion to accept the staff recommendation?
So moved.
Do we have a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On page 14 of the public meeting agenda, turning now to the Law Bureau's recommendation involving the data collection component of the Verizon reclassification implementation plan, we recommend the adoption of staff's recommendation, noting your statement, Madam Chairman, as well as the statement of Commissioner Cawley.
Do we have a motion to accept the staff recommendation?
So moved.
Do we have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Powelson. Any discussion? Commissioner Cawley?
Yes, Chairman, I have a dissenting statement which I asked to be placed in the record as if I had read it in its entirety. I wish to draw attention just to the one issue, and that is the aggregate reporting of data by Verizon. In other words, aggregate data from 153 data or wire centers as opposed to data from individual wire centers. This may sound like a very small matter, but it really goes to whether the information we receive is of any use at all. And it goes directly to whether we will allow Verizon effectively to hide the ball or not. What do I mean by that? Well, if you're going to use aggregate data rather than to get data on specific wire centers, you're not going to know what's going on in individual wire centers. And for example, what you're going to allow is it may appear that the quality of service in one wire center is perfectly all right, but it may in fact be declining and may not be on a par with wire centers where the services are being improved. The reality of what's going on, I think, needs to be reported to us on an individual wire center basis. And without belaboring the point further, I will allow my statement to elaborate. But I wish to be recorded as no.
Thank you, Commissioner Cawley. I'd like to put a statement on the record. There are some important issues about aggregate data filing in today's decision that need to be highlighted because they are important to examining the impact of our reclassification order. Should aggregate data be filed only on a competitive versus non-competitive category basis, or should the data be more granular and reported on a wire center by wire center basis within them? Should most or all categories be reported from the onset? Today's decision does not require wire center data, even though wire center data makes it easier to monitor the impact of our decision between wire centers across time. Today's decision only parses between competitive and non-competitive exchanges, providing only an average in all wire centers across time that can obscure large variations between wire centers. Today's decision also requires that aggregate data be filed for most, but not all, categories from the outset. Some categories are reported only if there is any rate change. It would be better to file all category data from the outset to create uniformity across time. This is better than waiting for any rate change to expect a report for a few categories. However, several factors warrant my support for today's implementation decision, even with these concerns. Nothing stops staff from inquiring after the data is filed. We can always modify reporting in response to subsequent developments. Finally, all categories are preserved and will be evaluated when studying the impact, including the few not reported at the start. There's no further discussion. We'll take the vote. All those in favor say aye.
Aye.
Any opposed?
No.
The motion passes 4-1, noting the dissent of Commissioner Colley.
It should be noted that the staff recommendation in the proceeding involving Gagan LLC's petition for waiver of the commission's tariff regulations governing limousine service has been postponed until public meeting of September the 17th. We recommend the adoption of the next Law Bureau recommendation in the proceeding involving the proposed rulemaking amending 52 PA Code Chapters 3, 5, and 23 pertaining to scheduled route and airport transfer service.
Do I have a motion to accept the staff recommendation?
So moved.
A second?
Second.
Motion by Commissioner Colley, second by Vice Chairman Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the Bureau's recommendation in the proceeding involving Duquesne Light Company's petition for an extension of time and all necessary waivers to implement its Phase 2 off-cycle switching solution.
Do I have a motion to accept the staff recommendation?
So moved.
Do we have a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Powson. Any discussion? All those in favor say aye.
Aye.
Any opposed?
No.
We have the vote of 4-1, noting the no vote of Commissioner Whitmer.
Turning now to matters presented on behalf of the Office of Administrative Law Judge. With regard to the first matter pertaining to ALJ Colwell's initial decision in the complaint proceeding involving Sharon Laffey versus Knox Energy Cooperative Association, Inc., there is the motion of Vice Chairman Coleman.
Do we have a motion to call up the staff recommendation for consideration?
So moved.
Do we have a second?
Second.
Motion by Commissioner Colley, second by Commissioner Powson to call up the staff recommendation for consideration. Under discussion, we'll call on Vice Chairman Coleman for his motion.
Thank you, Chairman. I'd ask that my motion be entered into the record as though I had read it in its entirety. Before us is the initial decision granting the Knox Energy Cooperative Association, Inc.'s motion for judgment on the pleadings and dismissing the formal complaint of Sharon Laffey. The complaint has alleged that the exposed gas service line on her property owned by Knox created a hazardous condition. The complainant asked the Commission to order Knox to bury the service line. While admitting that a portion of the service line was exposed, Knox denied that the hazardous condition existed. Additionally, it asserts that it is not a public utility subject to the jurisdiction of the Commission. The administrative law judge agreed that Knox was a bona fide cooperative, not a regulated public utility, and determined that it was appropriate to dismiss the complaint. I agree that Knox is not a public utility. However, Knox is a registered pipeline operator as defined by Gas and Hazardous Liquid Pipeline Act of 2011, also known as Act 127. Pursuant to Act 127, the Commission has been charged with regulating all pipeline operators within Pennsylvania consistent with federal pipeline safety laws. The Commission is empowered to promulgate regulations, conduct investigations, and impose civil penalties for violations of the law. We will take official notice of Knox registration of its Pennsylvania gas distribution facilities through its annual Act 127 registration form. Accordingly, the facilities at the center of this dispute are a service line. It is a pipeline facility subject to our jurisdiction under Act 127. Because there is no evidentiary record, it is not known whether there is a safety-related condition that should be investigated by the Commission's Bureau of Investigation and Enforcement. It is appropriate that BI&E have the opportunity to examine the safety of the facility at issue. The scope of this review is a matter of first impression of the Commission. Act 127 does not expressly address whether private party complaints are permitted. In considering this question, it is proper to consider the federal regulation scheme that the Commission is charged with enforcing. The relevant federal pipeline safety laws do permit private causes of action. However, the right is not absolute, and that these complaints may be preempted in certain circumstances. As we are charged with supervising pipeline operators in a manner consistent with federal pipeline law, I find it appropriate that we allow for private cause of action. For purposes of this proceeding, I find that the complainant has satisfied the requirement for bringing a private action under Act 2027. Accordingly, I will move that the matter be remanded to our Office of Administrative Law Judge for further proceedings. Knox stated in its answer in new matter that it was working with the complainant to relocate and bury the service line. If that has occurred and the parties are satisfied with the resolution, they are encouraged to file a certificate of satisfaction with the Commission. The proceeding on remand is stayed for 60 days in order for our Bureau of Investigation and Enforcement to contact the parties and conduct an investigation into the complainant's allegations. At its discretion, BI&E may intervene in this docket, or if it chooses, may take additional action as it deems warranted. Therefore, I move that the initial decision be reversed and remanded to the Office of Administrative Law Judge consistent with this motion, and the Office of Special Assistants prepare an order consistent with this motion.
We have a motion by Vice Chairman Coleman. Do we have a second?
Second.
Second by Commissioner Colley. Any discussion on the motion? All those in favor on the motion, say aye.
Aye.
Any opposed? The motion passes 5-0. On the staff recommendation as amended, is there any further discussion? If none, if there's no objection, we can take the previous roll call. 5-0. The staff recommendation as amended passes 5-0.
And finally, we recommend the adoption of ALJ Salapa's recommended decision in the proceeding involving the United Water Pennsylvania Inc.'s general rate increase and the joint petition for settlement presented therein.
Do I have a motion to accept the staff recommendation?
So moved.
Do we have a second? Motion by Commissioner Whitmer, second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you. If there's nothing further to come before us at this time, the meeting is adjourned.